quite a bit, it seems, about this idea of separation of powers and what's the court's proper role within that framework. We actually agree with one of the things in the state's brief. They quoted from the Rodriguez decision, stating that when there is more than one constitutionally permissible method of addressing the problems of financing and managing a statewide public school system, the legislature's efforts to tackle the problem should be entitled to respect. But the fundamental right to education established in 1965 was intended to establish constitutional checks and balances to legislative discretion in order to protect the constitutional rights of Connecticut school children. So we agree that the legislature should be given broad deference when acting above that right, and even given broad deference as how to specifically exercise and implement its affirmative constitutional duty. But when plaintiffs can show as a factual matter, and we recognize we have a high bar at trial to show that the state is violating its affirmative constitutional duty. Beyond a reasonable doubt is the standard this court has set forth. So we have a high bar to show that. But if we are able to show that, we do not believe it would be appropriate to simply give the legislature a pass and to let the constitutional rights of school children rest on whether the legislature will choose on its own to ameliorate those situations. If I could just talk for a moment as well about some of the procedural issues in the case and also the Geisler analysis. Just to make explicitly clear, we believe that we win in just looking at the legal factors alone. The text, the history, the precedent of this court, and the precedent of sister states courts. But we do believe that the mixed questions of law and fact in Geisler, questions of history and questions of socioeconomic considerations, are plus factors that would benefit plaintiffs in this case. And that given this court's practice with the Geisler analysis in cases like Moore and other cases where the court has considered these kinds of mixed questions of law and fact and undergoing its constitutional interpretation, we believe that that would also be appropriate in this case. And then, as with the question of procedure, we agree that it's not necessary for the court to accept the state's invitation to rush to judgment in this case, but rather can and should allow the trial court to develop the kind of factual record so that this very significant constitutional inquiry, which will have tremendous impact for school children across the state, can be conducted with all the relevant information before the court. If I could just talk briefly about some of the cases that the state has mentioned. The state brought up the Broadley case, referring that somehow our case is similar and that we use the word suitable, which is found in Section 10.4a. And just to reiterate, that is not the claims. That our basis for our constitutional claim is not simply the text of the statute, but rather rests entirely on the text of the constitutional provision and the history of and the other traditional Geisler factors. And I'd just also like to note that Broadley is a case that considered a right to special education for gifted students. So educational opportunities above what the constitutional floor required. And that is not our case, where we're simply asking for the basic opportunities that will prepare all students, regardless of where they come from, to be effective citizens and to participate in the economy. The court also the state also identified Moore as an important case for this court to consider. And there is an important difference between Moore and this case. As the court recognized in Moore, the difference is the text of the Constitution and the history of the constitutional provisions. So the court in Moore specifically looked to the text of Article 8, Section 1, and distinguished cases like Horton and claims brought under Article 8, Section 1 from the claims that were being considered in that case. Unless there are other questions, I'll just take a moment to sum up. 30 years from now, education in Connecticut will surely be very different from what it is today. But whether every child will have the opportunity to realize the fruits of education, regardless of where they live or who their parents are, is a question that will at least in part be answered by the court in this case. The principle of free public education enshrined in the Constitution by the people of Connecticut was intended to provide constitutional protections to the rights of Connecticut schoolchildren and ensure that all students graduate prepared to be productive members of society. The state's insistence that the court should either find this right to be without substance or close the door to plaintiffs' claims altogether simply cannot be squared with the inherent meaning of what a school is, the intent of the framers, or the precedent of this court. Nor should the state accept the state's invitation to rush to judgment before plaintiffs have the opportunity to present even a single piece of evidence. Rather than adopt the state's extreme position, which would place this court as the first Supreme Court in the nation to rule that the fundamental right to education has no substantive meaning, this court should reverse the trial court's decision below and allow plaintiffs to proceed to discovery. Thank you.
Counselors, we thank you for arguments of such a high quality. And with that, Mr. Marshall, we'll adjourn until 10 a.m. tomorrow morning.
Oyez, oyez, oyez. The Honorable Supreme Court, State of Connecticut now stands adjourned. Tomorrow morning, 10 a.m. All persons having cause or actually pending therein will govern themselves accordingly.